I'm Ryan Sanchez, and let's talk about Americans with Disabilities Act and employment. So, the big question, who exactly is covered under the ADA? Title I Law, Title I Employment. Provisions apply to private employers, state and local governments, employment agencies, and labor unions. Employers with 25 or more employees were covered under Title I as of July 26, 1992. Employers with 15 or more employees were covered 2 years later, beginning July 26, 1994. Title I of the Americans with Disabilities Act of 1990 prohibits discrimination, prohibits employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and any other terms or privileges. Hi, let's talk about the Americans with Disabilities Act of 1990 and employment. So the big question is, who exactly is covered under the ADA Title I law? Title I employment provisions apply to private employers, state and local governments, employment agencies, and labor unions. Employers with 25 or more employees were covered as of July 26, 1992. Employers with 15 or more employees were covered 2 years later, beginning July 26, 1994. Title I of the Americans with Disabilities Act of 1990 prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in job applications, procedures, hiring, firing, advancement, compensation, job training, and any other terms or privileges of employment. The ADA covers employers with 15 or more employees, including state and local governments. It also applies employment agencies and to labor organizations for entities covered under Title I. What exactly does that mean for business job application procedures, hiring and firing, advancement, tenure, layoff, and leave, fringe benefits, and any other terms and conditions of employment, including recruitment, advertising, and any other related activities. And speaking on that point, who exactly is protected under the idea discrimination in employment is prohibited against qualified individuals with disability? This includes applicants for employment and their employers and their employees as individual and considered of disability if he or she has been deemed mentally impaired that substantially limits one or more major life activities and has recorded such employment or regarded as having such an impairment. Person is discriminated against because they know or have known association or relationship with an individual are also protected under the ADA Act. Who exactly qualifies as a person with a disability? A qualified individual with a disability is the person who meets a legitimate skill, experience, education, or other of an employment position that he or she holds or seek, and one who can perform the essential functions of the position with or without the reasonable accommodation. Do I have to give job preferences to people with disabilities? as an employer is free to select the most qualified applicant available and to make all decision-based reasons unrelated to disability. Now, we hear a lot about reasonable accommodations. What exactly are reasonable accommodations? A reasonable accommodation is any modification or adjustment to a job for the work environment that will enable qualified applicant or employee with a disability to participate in the application process or to perform any essential job function. Reasonable accommodations also include adjustments to ensure that qualified individuals with a disability have the same rights and privileges, unemployment equal to those employees without disabilities. I get that, but what are some examples of those accommodations? Some examples of those would be restructuring a job, modifying work schedules, acquiring or modifying equipment, providing qualified readers or interpreters, or appropriately modifying examinations, training, or any other programs that the person may have to access in order to apply for an employer to accommodate a known disability of a qualified applicant or employee. The requirement generally will be triggered by a request from an individual with a disability, who frequently will be able to suggest an appropriate accommodation or accommodations must be made on an individual basis, because the very nature and extent of this disabling condition and the requirement of job will vary in each case. If the individual does not request an accommodation, however, the employer is not obligated to provide one. The employer's obligation under Title I is to provide access to an individual applicant to participate in the job application process, and for an individual employee with a disability to perform the essential job function of his or her job, including access to a building to the work site or other needed equipment, and to all facilities used by employees under Title I, and the employer is not required to make existing facilities accessible until a particular applicant or employee with a particular disability in accommodation to that employer. Modifications should meet that individual's work need. An employer can also hold employees with disabilities to the same standards of production and performance as any other similarly situated employees without disabilities. For performing the essential job functions with or without reasonable accommodation, an employer can also hold employees with disabilities to the same standards of production and performance as other employees regarding marginal functions, unless the disability affects the person's ability to perform those marginal functions. If the ability to perform those marginal functions is affected by the disability, the employer must provide some type of reasonable accommodation, but may not exclude an individual with a disability. And here's the big deal. One of our people who are currently using illegal drugs covered and under the 88, no individuals who are currently engaging in illegal use from the drugs are specifically excluded from the definition of qualified individual with a disability protected by ADA. When the employer takes action based on the basis of their drug use and follow up on that one are alcoholics covered, the ADA, a yes person who automatically uses alcohol and is not automatically denied protection of an alcoholic, is a person with a disability and is protected by the ADA if he or she is qualified to perform the essential functions of that job. An employer may be required to provide an accommodation to an alcoholic. However, an employer can discipline, discharge, or deny employment to an alcoholic whose use of alcohol adversely affects the job performance of their conduct. An employer may also prohibit the use of alcohol in the workplace and to require the employees not be under the influence of alcohol, as the ADA overrides federal health and safety laws. The ADA does not override health and safety requirements established under other federal laws, even if a standard adversely affects the employment of an individual with a disability. If a standard is required by another federal law, an employer must comply with it, and it does not have to show that the standard is job-related and consistent with business necessity. ADA employment law is covered under Title I. Also extend to describe nation based upon association or relationship with somebody. Let's explore the ADA prohibits discrimination based on relationship or association in order to protect individuals from actions based on unfounded assumptions that the relationship to a person or an entity with a disability would affect their job performance and from actions caused by bias or more misinformation, completing certain disability. For example, this provision would protect a person whose spouse has a disability from being denied employment because an employer's unfounded assumption that the applicant would use excessive leave time to take care of the spouse. It would also protect individuals who does volunteer work for people with HIV and AIDS from disciplinary employment action motivated by the relationship or association, and what type of record keeping does an employer need to maintain concerning disability law. An employer must maintain records such as an application form submitted by the applicant and other records related to hiring requests, reasonable accommodations, promotion, demotion, transfers, layoffs, or terminations, rate of pay, and or any other terms of compensation if a charge of discrimination is filed or an action is brought by the EEOC or the HICO Employment Opportunity Commission. An employer must save all personal records related to the charge until the final disposition of the charge. An employer can also establish a tenant and leave politics that the uniformly applied to all employees, regardless of disability, but may not refuse leave needed by an employee with a disability. If other employees do get such leaves, an employer may also require to make adjustments in leave policy as a reasonable accommodation. The ADA requires that employers post notice describing the provisions of the ADA. Oftentimes will find these breakdown. It must be made accessible as needed to individuals with disability. A poster is available from the EEOC summarizing the requirements of the ADA and the federal legal requirements for non-discrimination, for which EEOC is enforcement responsibilities. EEOC also provides the guidance on making the information available and accessible for all people with concerning Title I. So who exactly enforces the ADA? An individual or a specific class of individuals for their representative allegiances. Discrimination may file a form with the DA enforcement enforced under the same procedures now applicable to race, color, sex, national origin, religious discrimination under Title VII of the Civil Rights Act of 1964, as amended, and the Civil Rights Act of 1991. Complaints regarding actions that occurred on or after July 26, 1992 may be filed with the EEOC or designated state human rights agencies. And concerning a complaint, what type of remedies are available? Some of those include hiring reinstatement, promotions, back pay, prompt or restored benefits, reasonable accommodation, attorney's speed, exert witness fees, and all court costs, compensatory and punitive to your case, may be available in cases where discrimination from an employer has been proven to make good faith on your reasonable accommodation complaint. I would like to thank you for your time. This is all I have on the Americans with Disabilities Act of 1990. Again, my name is Ryan Sanchez, and thank you for your time.